Welcome back to Federal Entity and Gaming Law. With regard to slides, they should be up by the end of the week, and videos should be caught up by the end of the week. So everything should be up there. Today we're going to continue with gaming, advertisement, First Amendment. With regard to guest speakers, we just have to take them when we can get them, and that's when I could get Glenn Feldman. Hopefully you enjoyed Glenn Feldman's presentation. I've had Glenn as a guest lecturer on and off, I guess, for the better part of 15 years. And when he first started giving that presentation, he did carry in a cassette player and would press play in the classroom, you know, for the different areas of the recording of the Supreme Court hearing, the oral arguments. And the other thing is that, you know, at the time he was a young lawyer, relatively new, and a lot of the tribal work wasn't very glamorous at the time. And so I don't know if anybody's ever worked before in a larger organization, but everything kind of rolls downhill. And this is one that kind of rolled downhill. It landed on his lap. And the next thing you know, a couple of years later, he's arguing before the Supreme Court. So some of those assignments you get when you're a young attorney don't sound so wonderful maybe, but you never know where they're going to lead to. So just kind of as a career tip, something to kind of keep in mind. The reason we're going back to gaming, advertising, and First Amendment is right now this is becoming a very, very hot topic in gaming nationally and internationally. So we'll kind of start with a little bit of a refresher about where we were on this last week. Again, commercial speech is speech related solely to the economic interests of the speaker and its audience. For companies, for businesses, generally anything they publish is deemed to be commercial speech because they're deemed to be economic entities. So there, as I mentioned before, there was a case coming down the line that eventually settled where Nike was claiming that one of its full page advertisements or editorials, depending on what you say, was not commercial speech and therefore entitled to a heightened degree of protection. But like I said, that never came about. And I think Chief Justice Rehnquist was looking for the right case to get rid of commercial speech doctrine at some point in time, but it never happened. So what is protected under the First Amendment? Well, the First Amendment protects commercial speech from unwarranted government regulation. Again, that's not no regulation. Government can regulate speech, commercial speech, but it can't be unwarranted. So what's the test for determining whether it's unwarranted? You go back to that Central Hudson test, and it's still good law even today. And that test is, does the speech concern lawful conduct or is it misleading? If it concerns unlawful conduct, government can regulate it. If it's misleading, government can regulate it. And this comes up occasionally where a lot of this action has occurred in the last, 5-10 years is with dietary supplements. So dietary supplements making claims about health benefits and the FDA cracking down on those advertisements as misleading unless you can prove it. And it has to be substantial proof. Because, you know, we've had this problem in the United States, I guess, forever, you know, the snake oil salesmen and things like that. We don't see it too much with gaming. We have seen it with gaming with regard to offshores, but it fails on the first prong. Does it concern lawful conduct? You know, if it's an offshore gambling site, that conduct's not legal here. So no dice. Second part, if the speech does concern lawful conduct, and it's not misleading, then does the restriction serve a legitimate government interest? So the government can't regulate commercial speech just because it wants to. It has to have a legitimate interest. And then part three, does the restriction actually directly advance that interest? You know, you might have a legitimate interest in curbing problem gambling, but you know, making broadcasts of sporting events probably are illegal, probably doesn't directly advance that interest. Part four, is the regulation or restriction no broader than necessary to serve that stated interest? And we went through some court opinions on this. You know, we went through Posadas, and in Posadas, the legislature was allowed to determine what was a legitimate government interest. Court basically just took judicial notice, said, well, we're confident that the legislature has a legitimate interest because they've said they do. And then Posadas also said that the legislature can determine whether their remedy directly serves that interest by the enacted legislation. So again, they didn't really have to prove it. They just had to assert it. And then with regard to being narrowly tailored, Posadas said, well, the legislature can determine within reason whether the legislation is narrowly tailored. And again, in Posadas, the government interest was preventing local gambling or gambling by locals in casinos rather than tourists. And then the big bright line rule came in at Posadas that for any activity a legislature can prohibit in its entirety, legislatures have the lesser included power to permit the activity while limiting speech about the activity. So because the legislature of Puerto Rico could have made gambling illegal in its entirety, you know, like Utah has or Hawaii, they have the lesser included power to permit gambling but limited speech. So, you know, big case. It's a Supreme Court case. Government of Puerto Rico is very happy. And then we get to Edge. And again, in Edge, the legislature can determine what is a legitimate government interest. And in this case, it was respecting the rights of states that have lotteries while respecting the rights of states that don't have lotteries. And the legislature was allowed to determine whether that interest was directly served by the enacted legislation. And again, the court reaffirmed that legislatures can determine within reason whether the legislation is narrowly tailored. And then on top of that, the analysis of whether the speech is unwarranted, the restriction on speech is unwarranted, doesn't matter in a particular application. So it doesn't really matter with regard to the particular litigants or circumstances, but you have to kind of look at the analysis in the aggregate. And again, in Edge, did the government's restriction on speech really have any effect as it relates to the litigants? No, because that station was in North Carolina. It had a Northern Virginia audience. That audience was getting advertisements about the Virginia lottery from stations located in Virginia. Whether that station that happened to be located across the border broadcast those ads or not really would have zero effect. But that wasn't the point. The point was whether the law in the aggregate supported that legitimate government interest of respecting the rights of states with lotteries to have lotteries and advertise those, and respect the rights of states without lotteries to prohibit that kind of advertising. So we move on from Edge to 44 Liquor Mart. Oops, this is backwards. And in 44 Liquor Mart, we had this huge change. But again, remember, these are cases where it's the Rehnquist court, so it's 3 judges joining the majority opinion in parts 1, 3, 5, and 6, and 3 other justices in parts 2 and 4, and you know, these are kind of all over the place. So they're not as robust, I would say, as some other decisions. So those decisions you have from the Burger Court. And here, the legislature can no longer determine merely by stating that it has a legitimate government interest. It actually has to have some credible evidence to support that. It also has to now have credible evidence that the interest, that legitimate interest, is directly served by the legislation. But they will allow the legislature to determine within reason whether that legislation is narrowly tailored. It doesn't have to be perfect, but it has to be reasonable. And the big one is they talk about Posadas and say that just because the legislature can prohibit an activity in its entirety doesn't mean they have the right, the lesser included right to permit the activity while limiting speech about the activity. So they completely reverse Posadas here. And it's a big, big change. It's a big change from, okay, government, if you say it's an issue and it's a legitimate issue, and if you say this advances addressing that issue, then we'll take your word for it. Not anymore. And you don't have that lesser included power. Which then brings us to Greater New Orleans. Again, like 44 Liquor Mart, you have to have credible evidence for both the legitimate interest and to show that the interest is served by that legislation. And on top of that, not only is Posadas out, but as it relates to commercial gaming, so is that analysis in the aggregate. You actually look at the parties. Alex, you have a question.
Yeah, since you mentioned, like we talked about last class, these cases were such big changes from sort of the standard before. Were there any, I guess, like events or like changes in the makeup of the court that kind of helped to explain why there was such a stark change at this time?
There were some changes in the court. You're right. The court became a bit more conservative. And as I said, I think Rehnquist was looking for ways to chip away at commercial speech doctrine so that there would just be no such thing as commercial speech, which he thought in speeches and in interviews was something that the Supreme Court created whole cloth and really didn't have a whole lot of love for. He thought all speech was entitled to the same levels of protection, period. Now, how that would play out with deceptive trade practices, don't know. I mean, there is that Chicago style of economics that says, well, let the market determine. If your advertising is fraudulent, the market will eventually punish you. Of course, in the meantime, you're bilking a lot of people out of money, and if you move fast enough, you can keep doing this without getting facing the ramifications. So I don't know where that would have ended up, but Rehnquist was definitely looking at cases to chip away at commercial speech doctrine. But we end up with Greater New Orleans, and the uptake of it is that as it relates to commercial gaming, speech about commercial gaming is entitled to a heightened level of protection. So in this case, again, the government restriction on speech that applied to commercial gaming did not apply to tribal gaming, to horse racing, to charitable gaming, and to state-sponsored lotteries. They could still advertise, but just not commercial gaming. And in this case, the court said, this is so riddled with holes that there's no way it could serve the legitimate government interest as it relates to commercial gaming. And therefore, speech about legal and regulated gaming is subject to general commercial speech protections, sort of a heightened degree of protection. And it should be up to the listener to decide whether those advertisements provide relevant information for their gambling decisions, not the government. So big change. was a big change for the gaming industry. Until Greater New Orleans, there were a number of restrictions on what gaming companies could and couldn't advertise on radio and in television. You know, there's a great Borgata ad. I should probably show you that. Let's see if I can find that. I keep talking about it. I don't know why I didn't just go grab it before, but let's pull it up. If it's still available. If it's still here. Yes, it is. So let me switch the share here. Go to this one. Okay, ready? Now, what you notice there is that, you know, Borgata doesn't show you slot machines. They don't promote the gambling activity. You can see the word casino, but only as it's part of the name of the property. And that's what gaming advertisements look like. Now, today you can show slot machines. I mean, you watch TV now, and you know, stations has ads on, you know, FCC regulated TV where they show slot machines. They show winners. Same thing with Boyd. So, but at that point in time, Boyd and MGM, who did Borgata when it opened, couldn't do that. So there was still restrictions on those ads. So you show other aspects of the casino, but this was a big change for gaming companies. Let's go past this. So what was the DOJ's response to this? Well, the Department of Justice said that truthful advertising concerning lawful gambling operations, except as to state lottery in some circumstances, would violate the First Amendment. Accordingly, the Department of Justice will refrain from enforcing the statute with respect to such mailings, and the same thing occurs with regard to broadcast. So Janet Reno sent a letter to the Speaker of the House of Representatives back in 2000 and said, we're not going to enforce this anymore in that context. Now, what about state lotteries? Do you think Greater New Orleans has any impact on state lottery advertising? Alex?
No, I don't think so. I think
No.
it still generally stands for, like we talked before about the proposition that the federal government is going to let states kind of have autonomy and jurisdiction over whether they want to have a state lottery or not.
No, that's it. I mean, you couldn't have a television station in Jean right along the California border taking advertisements for the California lottery, just like Edge. Edge is still good law in that respect. Now, you could have a television station on the California side broadcasting ads for the California lottery, even though it reached Nevada as an audience, but not the other way around. So the lottery prohibitions still remain, but that wrinkle in 18 USC 1302 and 1304, where you have all these exemptions and casino gaming isn't one of them, that no longer applies to casino gaming. So commercial gaming can advertise just like travel gaming, just like horse racing. You're fine. But it was a big change. It was a really big change. In Nevada, we do regulate speech about gaming. So we have regulation 5.011. And the board and commission deem the activity on the part of any licensee as agents or employees is harmful to public health, safety, morals, or good order, or general welfare of the people of the state of Nevada, or would reflect or tend to reflect discredit upon the state of Nevada or the gaming industry to be an unsuitable method of operation and shall be grounds for disciplinary action by the board and commission in accordance with the Nevada Gaming Control Act. Basically, you have to conduct advertising in a way that upholds public health, safety, morals, and good order in the general welfare of the state of Nevada. So what does that mean? Well, in that, sub 4 is failure to conduct advertising and public relations activities in accordance with decency, dignity, good taste, honesty, and inoffensiveness, including but not limited to advertising that is false or materially misleading. So you can't do any of those things. Anybody seen casino ads recently? Courtney.
Yeah, I was gonna say, it seems like recently they've become like more risque, and I've heard from other people in the community that that's been like controversial.
Yeah, I mean, when I moved to Nevada back in '99, there was no Boyd School of Law, so everybody had to come from somewhere else if they were an attorney. You had to either be from the state, go somewhere else to get a JD, and then come back. But we also imported a lot of people like me. And the firm I worked at used to have large hiring classes. I mean, 12 to 17 people a year. And we did that because there was an attrition rate that first year. And a large part of the attrition was people that moved here and realized this isn't where they wanted to live. And I can remember at least 2 colleagues who were married and their wives really didn't like living here because at the time there was a show at the Riviera called Crazy Girls. I don't know if anybody here is old enough to remember that, but the advertisement I think was, I don't know, 5 or 6 women in, I don't know, thong bottoms, shot from the backside, and it was on every cab. It was on poster or billboards everywhere, but it was everywhere. And then there were other similar advertisements, and it clearly offended a fair number of people. I guess I didn't pay that much attention to it, and neither did my wife, but it was an issue. So racy advertisements are really nothing all that new, but they did reach a crescendo at Hard Rock under old management there when Peter Morton owned Hard Rock. Now, Hard Rock, for those of you that know the Hard Rock story, it was formed by 2 guys. Peter Morton was one of them, and they had a falling out, and they split up the brand between the 2. And Peter Morton ended up with casino resort hotels west of the Mississippi in South America, Chicago, and New Orleans. And his partner got everything else. So the restaurants, any other casinos, hotels east of the Mississippi were owned by his partner. Now his partner formed something called RPM Entertainment that went bankrupt, and the Seminole tribe eventually bought that half of the business. So the Seminoles own the Hard Rock brand, but at this point in time, Peter Morton still owned the Hard Rock Hotel. And let's take a look at some of the ads. So anyway, I should go back a little bit here. One ad they had, and we'll show you the ad, is at the Hard Rock Hotel, we believe in your Monday night rights, large quantities of prescription stimulants, having wives in 2 states, the big score football on Monday nights. Tell your wives you're going. If they're hot, bring them along. And that was kind of the straw that kind of broke the camel's back. And the Gaming Control Board brought a disciplinary action against them. And in 2004, the control board tested its power. Now, Hard Rock had another ad that also made it into the complaint. It was this one. There's always a temptation to cheat. Pretty racy. It was on billboards. It was on a billboard, I think, just outside of McCarran or the Reed, now Reed Airport. And the board said, this is problematic because it conveys that cheating at gaming and lounging on piles of gaming chips is acceptable behavior at the Hard Rock, which it isn't and it can't be. Cheating's illegal. And therefore, they added this to the complaint. By the way, here's the big score ads. So you can see the one in the forefront. And I have to thank Professor Roberts for this slide. She's the one that actually found a copy of the ad, but these are hard to find these days. I wished I would have taken photos of the billboards and things when they were up. But again, here it's, again, the large, at the Hard Rock, we believe in your Monday night rights, large quantities of prescription stimulants, having wives in 2 different states, the big score, football on Monday nights, football, beer, girls, and oversized parking. Tell your wives you're going, and if they're hot, bring them along. And the control board said this is a problem because the ad conveys the possession of large quantities of prescription stimulants and bigamy are legal and acceptable activity among our patrons. Violation of Reg 5.11.1 and sub 4. Now, the Hard Rock did face disciplinary action, and this is one, I don't know if anybody's ever followed a disciplinary action, but these usually get settled right away. There'll be an inquiry, there'll be an order to show cause, and usually you'll settle it right away before it becomes a complaint. Well, this didn't settle, it became a complaint. And not only did it become a complaint, it became a contested complaint, which is unusual. Now, those weren't the only ads that Hard Rock had. This was, again, just outside the airport tunnel. It was get ready to buck all night. Again, probably questionable with regard to inoffensiveness and public morals. Clearly this was done for the NFR, when the NFR is in town, but it got a lot of public community groups upset. You can see why. They had another one, which I don't have a picture of. I wish I did. It was in the airport tunnel going south when you first come out. And it was a woman with no clothes on, but she was holding dice strategically placed over her chest or out in front of her chest. And it had something about getting lucky at the Hard Rock. And again, this offended a lot of people. And Hard Rock was pushing the envelope. They had another one. This offended a few people or a lot of people. So you can kind of see where this ad campaign is going. And during the proceedings, their attorney told them to tone it down. Don't keep antagonizing the board. So they put this up on Paradise, right across from the Hard Rock. Another clean and inoffensive billboard. So, if you're their attorney, you're probably beside yourself. Stop. But they didn't stop. So they put this up. You can kind of get the idea here. I don't think I have to explain it. But it just did antagonize the board even more. And the Hard Rock was fighting this on First Amendment grounds, saying we have a First Amendment commercial speech right to advertise this way. It's not misleading. It's not promoting illegal conduct, which is why the board didn't go after this. It didn't go after Buck All Night. It didn't go after the dice. It didn't go after Looser Than Your Girlfriend. But it went after the prescription stimulants and the cheating. And they fought. And their response was, hey, this is broad and overbroad, and it's unenforceable. And what are community standards anyway? What's okay in our community is maybe not so okay in different communities. You've got the crazy girls ads with, I guess the best way for me to describe it is I had a 6-year-old nephew, and when he came to town and he saw one of these ads, he was, all energy at one point. He just grabbed my shirt and tugged on it. He said, Uncle Greg, butts. So, the Hard Rock did fight it, and they eventually settled. They settled with a $300,000 fine, and they had to have a compliance overview, or a compliance committee overview every advertisement before it went out. Now, the board looked at it as Hard Rock won. They got their way. But at the time, Hard Rock was not financially in great shape. When I moved to town, Hard Rock, on Paradise, Paradise and Harmon, it's a tough spot. And they had a slight resurgence after I moved here because they paid certain starlets to sunbathe at the pool topless, which then brought lots of people to come and see these Hollywood starlets topless at the Hard Rock. Well, that kind of ran its course. Then they were back to having a really tough time. And so what they really needed was an expansion. And what one of the gaming control board members said at the time was, once this settled, he said, well, we've settled the matter with Hard Rock, and now they want an expansion. And we're going to take a good, long, thorough look at their expansion plans and at the, and the plans to put in an additional tower. Well, you know what that means. And Peter Morton really needed to get that tower up quickly, and it just never happened, and declaring bankruptcy. So they may have won the battle, but ultimately they lost the war. So another key point on that is be careful when you're challenging a regulatory agency. Gaming is discretionary. You need a lot of permissions to do a lot of things. And, if you're challenging the regulator on a regular basis, it can make your life really, really difficult. And the regulator will still be within their power to, slow things down, investigate everything thoroughly. Just like they did with Hard Rock. So, bit of a cautionary tale with Hard Rock. Now, after this, I can tell you what happened because I was counsel to a couple of different compliance committees in town. Is other casino hotels decided, you know what? Let's have ads go before the compliance committee. So that if we have one out there that isn't real great, or it slips through, we'll at least have some cover. And Professor Roberts has one that didn't slip through that I didn't choose to show because it's pretty bad. But the fact that it made it all the way to the compliance committee was surprising, because they were going to put this on billboards, and it just like, no. Do you really want to get a disciplinary action started against you? So knowing what you know about commercial speech, knowing what you know about Greater New Orleans, knowing what you know about Hard Rock, what do you think about an advertisement like this in Nevada? This is not in Nevada, by the way. Courtney.
I think it's probably okay, unless like it's misleading saying it's the loosest slots.
Yeah. Oops. You know what? I got my slides out of order there.
But I think that could just be like puffery. Like I don't think it is necessarily misleading.
Well, the board says unless you can prove that you are the actual loosest slots, you can't say that. So there's a series of 2 letters, one in 94, and I'll read it because it's a little difficult to see here. The board has recently noticed that licensees are making a number of advertising claims, particularly on area billboards, cab signs, newspaper ads, which raise certain concerns. To note, just a few claims that a location has the best playback, maybe in the world, the most liberal slots, or the loosest slots in town, may be an exaggeration that cannot be factually supported. And therefore, it violates Reg 5.011 sub 4. So, and they backed this up again in 1999, 5 years later, same thing again. No dice, can't do it. And you will get caught. And you know why you'll get caught? Because your competitors are going to complain to gaming. Now, the way around this, back when the Maloofs owned Palms, is that the RJ, I don't know if they still do it, but they used to do a survey where they would go out over the course of a couple of months, send reporters to each casino to see who they found to have the best paybacks and the loosest slots. You could quote the RJ article. You could say RJ is named Palms the best value in slot gaming in Nevada. Fine. You're citing a source. Fine. But you can't just come out and say we have the loosest slots in town unless you can prove it. And you know what? There's no way to prove that because your competitors are not going to tell you how tight their machines are. But I can tell you back in the RJ days when they used to do these surveys, Palms is usually the loosest. And Venetian was the one closest to a parking meter. You know, money goes in and nothing comes out. So, but they all meet minimums. Minimum paybacks are, nobody even gets close to minimum paybacks. Everybody's well above that. But just know that if you're counseling clients in this area, you don't really have a First Amendment defense to the loosest slots in town or most liberal paybacks or most liberal slots or best payback or any of these exaggerated claims about gaming. They're just not going to fly. It's not going to be viewed as puffery. It's going to be viewed as deceptive. Courtney.
Yeah, just I guess going along with that, do you think it's because it's gaming specifically? Because there's so many businesses that advertise like best coffee or best whatever.
Well, I mean, you can say we have the best slots in town because best is kind of a relative term, but you can't say we have the best payback because at that you're starting to make claims that are quantifiable. And you're seeing, again, you see this one hot area for this kind of claim is dietary supplements. You know, if they're making a claim that can be measured, they better damn well have measured it to support the claim. And the same thing goes here. If you're saying you have the most liberal slots or the loosest slots in town, you better be able to prove it. And if you can't prove it, then you're in violation of Reg 5.011 sub 4. And this happens, I want to say, in about a 5-year cycle. And I think it has to do with people, turnover at gaming companies. You know, there's management turnover, there's advertising turnover, and then somebody comes up, oh, we'll just say we have the best slots in town, or best slots is great. We'll say we have the loosest slots in town. That'll get people in. Yeah, it will, but it's also going to get the Gaming Control Board on your back. So this comes back periodically. Know about it. Other states have similar laws about this. So, just realize that kind of advertising, at least in gaming, won't fly. Other jurisdictions. Now these are, again, I have to thank Professor Roberts for these slides. You know, on that 5.011 sub 4, what do you think of these ads? And these are not US ads. You know, mortgage, what mortgage? Courtney.
Yeah, that's the one I was going to comment on. It's like encouraging people to gamble away their money for their mortgage, and that there's like a huge public policy interest in not having that.
Yeah, that's a problem. You know, the Last Supper where they're playing poker. Probably not great. Once is lucky, twice is talent. You know, The Professional from Ladbrokes. You know, here's another set of them. You know, the statue in Rio with a sports bet jersey on it. These are Paddy Power ads that cause quite a stir as well. You know, odds on things making it more interesting. So this has become a hot topic in other places as well. And it's caused regulators in other jurisdictions to start making changes to advertising. So let me show you a video of one. Hopefully this is loud. You hear it?
Hello and welcome to the SBC News 90. Here's the top stories of the day. Spain's Council of Ministers has approved legislation limiting gambling advertising to a 4-hour overnight period beginning at 1 a.m. Although it excludes some lotteries, the Royal Decree on advertising applies to all traditional media. Operators in Spain must also ensure that digital and social media adverts feature age restriction filters, which must be approved by audiences before viewing. Additionally, gambling promotions and content can no longer feature endorsements from athletes or other celebrities. Welcome bonuses, meanwhile, will be restricted to a single offer capped at €100. Online.
What another one?
This is Kev. He manages this club and considers himself a bit of an ad man.
This one's sure to pull the crowds.
That's false and misleading and could be seen as encouraging the misuse of pokies.
How could you miss this one?
Well, that's not a reasonable statement.
Here we go.
Nope, that's not true.
All right, here it is.
Sorry, Kev. In Queensland, venues can only advertise externally if they comply with Section 229 of the Gaming Machine Act 1991 and Practice 6 of the Responsible Gambling Code of Practice.
Now, of course, they don't have a First Amendment like
the
we
federal
do.
government is cracking down on the broadcast of gambling ads during live sporting events. The restrictions are part of a new package of media reforms for Australian free-to-air TV, which are set to breathe new life into the industry. Candice White has this story.
They're in your face every time you watch live sport.
Power play with the blue button though, whooshka, up he goes to $5.
But not anymore.
Families want to have the opportunity to sit down in front of a live sporting event and not be faced with gambling ads.
Soon, betting ads will be banned from live sports broadcasts before 8:30 p.m. They also won't be shown 5 minutes before or after a game.
But at least now, there's much less of a chance that the kids of today will become the gambling addicts of tomorrow.
Last year, TV networks ragged in $120 million from gambling ads. But even the betting agencies say change was needed.
We absolutely welcome this. We certainly have long held the community's view that there's simply too much gambling advertising.
While the ban on gambling advertising may end at 8:30 p.m, the government cannot police parenting, and experts say it's up to families to protect children from the ads if they're staying up late.
For the odd ones that don't, the parents should be watching them.
The changes are part of a package of media reforms which include measures to secure the future of Australian broadcasters.
We want an Australian media that will survive and prosper.
The government will scrap the massive licence fees for TV and radio networks.
These fees really are from a bygone era.
Instead, they'll pay a much lower fee based on their reach.
These reforms will put big sums of money into the industry, into the television industry, long overdue.
He says the old fees were brought in before the internet.
Right now, you can get media content from all over the world, from many, many different places. It had to be modernised.
Laws that prevented one company or person owning a radio station, a TV network and a newspaper in the same market will also be scrapped.
All right, so you can see that, you know, changes are coming across the world. You saw Australia, you saw Spain. The UK has recently put restrictions on certain advertising because it was, you know, going pretty wild, like you saw from some of those examples. Italy has put restrictions on gaming advertising. France has put restrictions on gaming advertising. So you're seeing a lot of this in the Western world. And the American Gaming Association is trying to get ahead of this in the United States. You know, I can tell you our foreign friends find it remarkable that we don't have any national restrictions other than 1302 and 1304, which are pretty light and really at this point primarily apply to state lotteries only. So what has the AGA done? Well, they've come out with this code for responsible sports marketing. And the code contains several different principles. One, respecting the legal ages for sports wagering, supporting responsible gaming, controlling digital media and websites, monitoring code compliance, and requiring you to go through sort of a compliance process if you're part of the AGA and you're advertising sports wagering. So again, respecting the legal age, the AGA would like you to tailor messages so that they're not attractive to underage people. So no cartoon characters. You know, for anybody that's old enough to remember Joe Camel, if you ever followed that with the cigarette industry, you know, they had a Camel cigarettes had a illustrated camel that was really cool. And unfortunately for, I think it was RJ Reynolds, there were memos about making Joe Camel cooler to the younger demographic of 12 to 14-year-olds. So that was a problem for them in litigation when it came out. But the AGA is saying no cartoon characters, nothing that appeals to young audiences. You shouldn't have advertisements in media outlets that appeal primarily to those below the legal age for sports wagering. So, you know, advertising on Nickelodeon, Disney Channel, or Disney Kids, probably not a good idea. No sports wagering messages, including logos, trademarks, or brand name for use in toys, clothing, games, game equipment. And sports wagering should not be promoted or advertised in college or university-owned news assets. So fairly comprehensive here. Oops. Supporting responsible gaming, you know, messages should not promote irresponsible or excessive participation in sports wagering. You know, that mortgage, what mortgage? Probably would violate this. Each message should contain a responsible gaming message along with a toll-free helpline number where practical. Now in Nevada, we do require casinos to have problem gaming brochures available and helpline numbers available, and staff are supposed to be trained to direct people to those if they have questions. No message should suggest that social, financial, or personal success is guaranteed by engaging in sports wagering. And messages should adhere to contemporary standards of good taste that apply to all commercial messaging. Now, again, you saw those advertisements, with, poker at the Last Supper, a betting slip nailed to somebody that was hand that was being crucified. Let's make this more interesting. The Ladbrokes the Paddy Power where, the car's coming and it may hit one or two different old people crossing the street. Probably not in good taste. Controlling digital media and websites. Again, you should comply with all applicable provisions of the code for messages on websites. There should be a link to responsible gaming on web-based advertising. Websites owned by sports wagering companies should include a reminder of the legal age and age affirmation mechanisms. Should have geolocation. Again, we had GeoComply here. So more than just having geolocation for placing wagers, the AGA believes that you should use geolocation for where you place your marketing or ads. So you're not advertising to people where it's illegal to bet in that location. User-generated content on sportsbook-owned sites should be monitored for compliance with this code. Digital marketing communication should respect the privacy of the users. And you should have terms of use and privacy statements that support these policies as well. And then monitoring that code of compliance. The AGA will actually provide you with training. It'll deliver copies of the code to AGA members and advertising agencies and media buyers and third parties involved in member advertising. AGA members should adopt an internal review process to evaluate whether promotional and marketing messages comply with this code. Again, kind of coming out of that Hard Rock experience, AGA is trying to codify this for the industry. But again, this is just the AGA. It's not a government entity. And then you should have a commitment to the code. There is a compliance review board. Well, they will review complaints. And they have a complaint review process. Now, the only thing they can do is recommend changes to the advertising. Again, the AGA is not a government body. It is an industry group. Well, let me show you the current website for this. And this is brand new, by the way. This is less than a year old. Can you see that? So if you go to the AGA site, they have the entire code is available for download. And you can see that they have all these rules. They've also had one disciplinary action already, or one review. And the review is kind of inconclusive. We'll talk about that in just a second. I shouldn't say inconclusive. It was resolved, but resolved without any issue. And the issue was with Penn National. So the AGA received a complaint that Barstool Sports on January 15th, 2021 had an advertisement for the Can't Lose Parlay. That the Can't Lose Parlay directly violated the code, that no message should suggest that social, financial, or personal success is guaranteed by engaging in sports wagering. That's a problem. Now, Penn National responded that they aren't running that promotion anymore anyway, and they disagreed with the AGA's interpretation because it did have some language at the bottom of the promotion saying that Can't Lose doesn't carry any guaranteed social, financial, or personal success, and they thought it was more satirical. Now, is Can't Lose something you can measure? Yeah. But pursuant to the AGA's processes, they sent that back to the complainant. Complainant didn't ask them to continue the process, and therefore the AGA considered the process resolved. But you can see where this is going. Is if the industry doesn't get a hold of this on its own, we're likely to see restrictions in the United States similar to those that we've seen in friendly countries or countries with similar laws to the United States, similar cultures. I mean, Australia, UK, Ireland, to a lesser extent, Portugal, Italy, Spain, Germany, all have restrictions on advertising for gaming, particularly sports wagering. So it wouldn't surprise me to see some pushback from either at a national or on a state-by-state basis with regard to advertising for sports wagering. And in fact, here's another piece. And that was put out by by New Jersey's government. So it appears that New Jersey regulators are going to expect their licensees to follow the AGA code. So it's already starting to happen. But the AGA effort is clearly an effort for the industry to self-regulate before government steps in to regulate. And in other jurisdictions, self-regulation hasn't really worked a whole lot. I mean, again, I can show you those ads again from the UK. You know, clearly everybody's trying to push the envelope